Many small construction businesses forgo legal counsel to save on expenses but end up paying for it in the long run. Contractors of all kinds are at a disadvantage long before moving on to their project site, merely because some contract clauses are stacked against them. In this video, we are going to discuss the 4 construction contract clauses that possesses special challenge for contractors. No damage for delays. When a clause doesn't allow the contractor to get paid for delays, it is no damage for delays clause. These clauses often also limit the contractor's ability to extend the time to completion. Since construction is a very risky business and success often depends on the completion of project within a specific time, these clauses limit the claims contractors can submit when things beyond their control affect the schedule. An enforceable contract that allocates risk accurately should allow contractors to get paid for all the delays they don't cause. That should include the delays for acceleration, changed conditions, and disruptions. Clauses that affect claims like this one does also specify the time frame allowed to submit claims. The contract should allow ample time to provide delay notices and to submit claims. If you can't avoid no damage for delays clause, then have the contract list the delays for which you will not get paid, and insist that listed delays include only those which you have no control over. Second, indemnify, demand, and hold harmless. Throughout contract law, you often see clauses like indemnify, demand, and hold harmless. Sometimes these clauses includes only one or two of the actions. When you're assessing risk, you need to know what each of these words mean from legal perspective. If you agree to indemnify, it means you will reimburse the other party in the contract when there is a loss or damage. Ideally, you would only compensate for the risk that you have control over. That way, you're not offering to pay for losses and damages that someone else caused. When you agree to defend another party, you are agreeing to pay what it costs to defend them against a suit brought by a third party. Unlike when you agree to indemnify, when you agree to defend, there doesn't need to be a loss that's proved. You are immediately on the hook for a potential liability when a third party files a claim. When you agree to hold harmless, you're saying that you will both defend as well as cover losses, no matter who's at fault. The most important thing about these clauses is that when they are used properly, they place the risk with the party who's responsible. Unfortunately, they're often not used properly, by assigning all the risk to the project participant who has the least amount of leverage in negotiations. Subcontractors are prime targets for these type of misuse of clause. One way to avoid risk from this clause is to only agree to indemnify, demand, or hold harmless, where you have control over the potential losses and damages. Third, right to withhold payment. The owner's right to withhold payment for work is there to protect the owner. These clauses usually refer to withholding payment for delays, potential liability claims, work that doesn't meet contractual specification, and other risk. However, owners usually have some protection in the form of retainage. So the right to withhold payment should be limited to very specific situation. Contractors should also make sure that the contract language does not allow withholding payment for anticipatory breach of the contract. Fourth, reasonably inferable. There's a practice in construction contract law to use the term reasonably inferable in the general conditions portion of the contracts. This relates to the design documents and appears in the contracts to acknowledge that design documents are never perfect. It is up to the people doing the work to construct a project that sustainably matches the design intent. So if a drawing is showing a door, it is up to a contractor to include a frame with the door, even though frame might not be shown on the drawings. The contractor can reasonably infer that the door should have a frame. Problems usually come up when the design documents are so incomplete that contractors has to begin drawing too many inferences. The result is the contractor starting to construct on the fly with the materials and methods that might not match with the intent of the design. Or the contractor begins to rely on change orders to cover mounting unforeseen costs. The best defense against falling for this clause is to do a thorough review of the design documents looking for completeness and constructability. If the design does not pass your basic evaluation, then not getting involved in the project might be the best decision. Another option is to try to work out the design concerns before the final bid. This is not a complete list of contract clauses that could cause problems for construction businesses and is not a legal advice. But by being aware of these clauses and their potential setbacks could save you some money. To put yourself in the best position, always consult legal counsel when you're considering signing a contract.